Good morning and welcome to the business of expert witnessing. I'm your host, one of your hosts today, Nick Rishwain. You know me from Experts.com. I'm the Vice President of Client Relations and Business Development. Been in the expert witness game for 13 years now. Combined, Dan Sandman and I have a lot of insider industry experience. So we're going to share some of that with you today. Our guest host today is Dan Sandman. He is an expert witness industry insider. Dan is a practicing attorney and former private equity-backed company executive. He grew and scaled the nation's largest pure-play medical expert witness network as president of AMFS for 5 years, and he led the business development and operations team for 3 years before that. Before taking the helm, Under Dan's leadership, AMFS experienced exponential revenue growth and implemented new service offerings. Dan has facilitated more than 5,000 expert witness engagements and many more consultations between physician, advisors, and attorneys. Dan's experience extends beyond the boardroom to the courtroom, where he won numerous jury trials working with expert witnesses. He is a licensed attorney, has been for 20 years, and is now actively practicing in California and Illinois. Dan and I are about an hour apart from each other right now, very near each other in California. He started what is now Sandman Legal PC and Sandman Consulting LLC in 2022 in order to provide his legal and industry experience to professionals eager to enter and excel in the expert witness race. So with that, Dan, I've been telling people on LinkedIn and on Instagram that combined, we've got somewhere in the 20 to 25 years of industry experience in the expert witness industry. You from the broker side and as a practicing attorney, myself from the marketing and referral side. And we hope that that combined knowledge is very helpful for our guests today. The Q&A is open, folks. So feel free as we start talking here to ask your questions, and we will get to those hopefully in about 45 minutes.
Great.
Dan, glad to have you here. Welcome to part one. We already decided that part two is coming, folks, because there is so much information that we created in this outline that we had to break it up.
Well, that's great, Nick. It's great to be here. Thanks so much for having me. You know, you might be about an hour or so away, but, you know, I feel like I can reach out and touch you because you're right here. And Nick, you and I have been connected for a long time now, and I'm really thrilled that we're able to collaborate on this together today.
Yeah, I should say that in Dan's his former work with AMFS, he was a customer of Experts.com. So we're now combining our knowledge, and it's always enjoyable to see you. Please start with a little bit. You're out of the expert witness brokering space, Sandman Legal and Sandman Consulting LLC. What is it that you are now offering in the expert witness space?
Absolutely. And before we get into things, I do want to say that I am a practicing attorney, and that, you know, really we're going to be talking about industry trends and practices, things of that nature. So anything that I do say that could be construed as legal advice, don't take it as such.
He's not your attorney.
You're right. I'm not your attorney, but you know, who knows what the future may hold. But talk to your own personal attorney if you have questions about any legal implications of things that Nick and I may be discussing. But so thanks, Nick. Yeah, you know, back about a year and a half ago, it seems, I had an idea, and I went with it, and surprised a lot of people, and decided that I really wanted to put my law practice hat back on and my consulting and start some consulting with folks who wanted to get involved in the expert witness business. And I just had an idea, and I've been running with it for the last year and a half to provide legal services to expert witnesses, you know, mainly in the area of contracts and insurance consultation and general counsel services for expert witnesses, to make sure that those who are in the expert witness space or want to enter the expert witness space, professionals who want to enter the expert witness space, have the right legal foundations to make sure that they're successful in the work that they do. On the consulting side, which I do nationwide, there's a lot of business and operation pieces that can be really important to know about if you're an individual working on your own as an expert witness, or if you're an expert witness company, legal services company. And I provide that consulting on an individual and corporate basis to folks around the country.
Excellent, excellent. So, and it's great that you have both the law firm and the separate consulting side, because we're going to get into that a bit as far as business entities later in the chat. So you've got actually your own personal experience on that.
Oh, I do.
So we'll jump right in. As you and I had discussed, we've got kind of for those of you who are coming in, there's a lot of you. We're going to do essentially retainers today, fee schedules, business entities, and insurance. And we may if we have some time, touch on the marketing stuff.
We got to touch on marketing a little. Everybody wants to know how to get more business.
Yeah,
so
we'll touch on the marketing.
We just got to.
We're going to touch it, and then part 2 of this will, which you'll be notified about via email, will be almost predominantly on the marketing side. So, Dan, retainer agreements are always an issue for especially those new to the expert witness game.
Mm-hmm.
Can you just tell us broadly, what is a retainer agreement, assuming we have some people in here who are brand new?
Yeah, the retainer agreement is the agreement between the expert and the retaining lawyer entity that sets out the terms of the expert witness engagement. It's pretty much that simple, and it can always be that simple if you have one that's appropriately drafted for your business. Not having one is an ongoing problem and challenge, I think, for a lot of experts who have been in the business for a long time and those who are looking to enter the business. Nick, I think you agree with me on this, that doing expert witness work, however small the engagement, or whether it's a multi-million-dollar large, fraud case, white collar type thing, doing without a contract, an engagement agreement probably isn't the best idea.
Yeah, I mean, this is right. This is out of law school, 1L law school stuff. If you're doing it without a contract, there's a problem, or it could be a problem.
There will be a problem.
There will be a problem, and I don't
yeah.
recommend it for anybody. So,
right.
So tell us kind of broadly why it's important. What does the retainer agreement lay out for folks?
There's so many reasons why it's important, and I we probably could spend the hour talking about it, but then people will start dropping off saying, I didn't sign up for a law school class.
Right.
So we'll paint in some broad strokes, but get a little specific with a few things if you'd like. And it's so important for credibility purposes. It's important to have one because it's going to reflect the business practices of that expert. And it's important for the lawyer to understand what the expectations, or for the lawyer to know what to expect when working with that expert.
Mm.
If you just work with a fee schedule, or you just download something off the internet, there's a good chance that that's not going to reflect practices that you as an expert have thought through and consulted about with a lawyer or business advisors about how to structure and operate your business. At the end of the day, if you have a good contract that works for you and reflects business practices and works to address legal issues that can come up and forestall problems with the engagement going down the road, it's going to lead to repeat business for that expert. It's going to lead to enhanced credibility for the expert. And it's just best business practices, no matter what you're doing, from carpet cleaning to testifying on the stand in a major trial.
Yeah, fantastic. And kind of a broad overview here for our audience today is what are some of the kind of main terms that need to be included in a retainer agreement?
Sure. So you can sort of divide up the world in the business terms that become legal terms because they're in the contract, but sort of the deal points, if you will, and the legal terms. So let's start with some of the deal points. So obviously you want to have what your hourly billing is going to be, if it is hourly billing, what your billing rate is going to be, and how that's going to work. Billing is again, that's another fun one, because there's more to it. If you're looking to grow for growth and revenue, there's more to it than just I charge $500 an hour. There's ways to structure rates in such a way within your contract and fee schedule that are going to make you appeal more or sometimes less to certain clients, and are also going to drive revenue in ways that maybe the expert hasn't necessarily thought of. And where that very often comes into play is in the area of testimony. So a lot of the billing rates and the deal points have to be spelled out in terms of how cancellation fees work, how testimony is billed, is there a non-refundable or refundable retainer? These are important business points that become part of the deal in that contract. Other things that are really important too on the legal side are limitations of liability, perhaps an indemnity agreement, which I know is one of your favorites, Nick, to talk about indemnity. I'm
Sure.
just kidding. Indemnity agreements, Nick and I talk about this stuff, over beers. Let's talk about indemnity agreements. This is really going to be exciting.
Really exciting stuff, but it does
Yeah.
come up later in our discussion as well when we talk about your business entity as well as your E&O insurance. These are an ongoing theme here for the audience, is that there are ways to limit liability.
Sure.
That is.
Yeah, and let me just throw in, I'm sorry that you dropped there for a minute, but I think I got you back. Also something to think about in a contract is an arbitration agreement. How are disputes going to be resolved? Disputes do come up. And when we touch on insurance, there's a case that I always like to refer to. I'm not going to spoil it right now, that there are situations where experts wind up in litigation because of something they were perceived to have done, but maybe didn't do, or maybe they did do, and it created a problem for the case. So arbitration agreement, mediation agreement, alternative dispute resolution clauses within the expert contract, something to think about, because it can keep you out of court and hopefully resolve a dispute should it come up in a more painless way, if that's
Painless, hopefully cost effective.
Hopefully more cost effective as well is one is for sure.
Yeah.
Something that's important. Yeah.
So those are some good kind of overviews, and this is what Sandman Legal would offer, right? In
Sure.
agreements for folks.
Sure. We're always happy to review expert witness retainer agreements, engagement contracts. There's a number of different ways that you can sort of refer to them. Do a review of what already is in place, make suggestions about how it can be improved, and we also draft those agreements from scratch, and we customize them to each client, because Dr. Smith and Accountant Jones, those are two different types of businesses. They're going to want to schedule their fees in different ways. They may have different business practices that they want to be reflected in their agreement. One thing I just really caution people about is downloading or sharing agreements. It's just, there's no guarantee that what the agreement that your friend has is going to be applicable to how you want to run your business.
Yeah.
And you can learn from them. You can sort of look at it, but it's really important to work with an attorney who understands the agreements and can make sure they construct something for you that is reflective of your business and is going to be something that you understand. So if problems do come up, that you know how to address them in your way.
Excellent. And I see that we're getting a lot of questions on retainer size, upfront, non-refundable, et cetera. And keep upvoting those questions that you find most beneficial. Help each other's questions go to the top so that we know which ones to hit when we get to the Q&A. We'll try and get there in about 30 to 45 minutes. So keep them coming. We are very happy to hear that you are engaged with your questions. What are some problems or issues that you've seen in retainer agreements in the past, or things that were left out that became a problem that you would never want to have left out?
Yes, I'll tell you, one of the problems I've seen in retainer agreements is that sometimes they're just too long. And that sounds really kind of lame, like really, but yeah, really, because I've seen some retainer agreements for basic engagements that are 20, 30 pages long.
Oh, wow.
Now, in major litigation with lots of implications and millions of dollars in expert fees, that may be something that in a very unique situation may be warranted. It's really the outlier. So it's important to remember that the document that you're presenting to a client or prospective client is one of maybe many documents that will be considered because they're looking at a bunch of other experts, okay?
Mm-hmm.
So I draft things in a way that I think and that I recommend others draft as well when they ask me how to do it, in more of a plain language sort of approach, okay?
Mm-hmm.
Something that clearly lays out what your policies are, how billing is going to work, what's going to happen if the retainer runs out, and what the expectations are for replenishing that retainer. So one of the biggest mistakes I think an expert can make is have a contract that is just so difficult to understand and get through that it's
Mm-hmm.
going to turn someone off from retaining them. Now that's sort of subjective, because a lawyer at a white shoe law firm might throw it to an associate and say, here, figure this out. That's usually not the case. You want it to be user friendly, but you want it to protect your bottom line and your reputation and your business. Some of the things that I see left out also are those arbitration agreements that we talked about, are alternative dispute resolution approaches to disputes that that may come up from time to time. Other things that I have also seen left out are simple things like who's going to pay for travel and how's
Mm-hmm.
someone going to get reimbursed, and
I
are they
suspect you want to have things for dissolution of the retainer agreement as well.
termination fees, make it
Termination.
very clear. And uh, one of the things that has been a problem, and I've been counseling some folks on this, is what happens if there's a Daubert challenge. A Daubert
Mm-hmm.
challenge should be in, our expert witness business part 3, history of the world part 3.
Yeah, right.
So, but you want to be notified. You want to be
Mm-hmm.
notified and be made aware that that is going on. And if not, that could be grounds for termination of that agreement for non-compliance with the terms of really what a lawyer should be doing when working with an expert, but it happens. So you as
Yeah.
an expert want to make sure that that's in your contract as well.
Excellent. And I suppose one of the other things that I've seen come up, Dan, um, in the years doing in this business is I'll get the complaints about, boy, they haven't paid me in a long time. So you probably want a term in there about frequency of payments, and
Nick,
it's going to be billed monthly, or how are you doing?
you're right on the money. You're right on the money. And you want to have it very specific about how you're going to be billed, how the expert is going to bill the client, how you're going to deal with a case where someone doesn't pay.
Yeah.
You want to have outs. You don't want it to be so onerous that somebody reads a contract and says, oh, there's, the duties of the expert are to do their job, quote unquote, but they have 15 different ways of how to get out of this thing. That sort of sets off some alarm bells sometimes
Right.
too. But if
Right.
someone isn't paying you, if they're not notifying you of a Daubert challenge, if they're being nasty and combative, you need to have certain language in the agreement that gives you the opportunity to get out of it.
Excellent. And this is a big one that comes up over and over. I get calls or emails from our Experts.com customers who are asking whose agreement should we use?
That's right.
Right. Do we use, well, the lawyer presented me with one, or do I use my own?
Look, I would say 9 times out of 10, you should use your own. Use your own. It's your business and they're retaining you. If you're in a situation where you're kind of not going to get the engagement, you really want it, unless you go with the law firm or the insurance companies or the retaining entities piece of paper, get it reviewed by counsel before you sign it. I know it
Yeah.
sounds obvious, but a lot of times it's not done. I do, Nick, have people come to me say, hey, I tried to use my agreement, but they wouldn't let me use it, and they made me sign this, and now I'm saying that I need to be paid, but there's something in the agreement that says they don't have to pay me if XYZ, and I didn't know that was there. I said, well, would have been better if we talked about this 2 months ago.
Right.
So we try and work it out. We try and work those situations out. But I would say 9 times out of 10, 9.5 times out of 10, use your own agreement, try and make adjustments to your agreement with your counsel, rather than using another party's agreement if you can.
Yeah. So for the audience here, this is the same thing we tell attorneys almost. Involving an attorney early is better for you than involving them later. The same that we tell attorneys about involving an expert early is better for them than waiting till the last minute. So keep that in mind.
No
Keep that in
question
mind.
about it.
Yeah.
No question about it.
And final, probably main thing that I wanted to cover that you and I discuss and agree on here is that when the expert presents their retainer agreement to the law firm, you want the law firm to be the one signing the agreement. They are the responsible party. They are who you're contracting with. You're not contracting with their party. Generally, you're about to tell me some of the well, it depends issues, but mostly our idea is the best outcome for an expert is to have the law firm as the party responsible and the one who is contracting with the expert.
Nick, that's 100% right. And this goes back to a question you brought up just a moment ago, which is what are terms that if they are left out of the contract, the retainer agreement, become a problem. And I should have mentioned this one, and you just reminded me, and that is there should always be a clause that no matter what the local practice is in a specific jurisdiction, wherever that engagement may be, that the retaining law firm, if we're talking about a law firm that is retaining the expert, they pay. How does this problem come up?
Mhm.
This problem comes up and they say, oh, well, you've been asked to give a deposition by opposing counsel, and opposing counsel is going to pay you. Okay, they'll bring a check to the deposition. And as an expert, you go to the deposition and there's no check. They say, oh, we'll get the check to you. And the law firm that retained you said, oh, they'll pay you, don't worry. And 3-4 months go by and they haven't paid. At the end of the day, the retaining law firm needs to be responsible for that. It's the right thing to do. It's what I did when I practiced. There's people who are going to want to disagree, but you know what? Sure. If I had a good relationship with opposing counsel and I knew they were going to bring the check and pay my expert, fine. But if after 3-4 months went by and they never did, I didn't want to leave my expert out to dry, out chasing someone who they have no privity of contract with.
Yep.
They have a contract with me when I was practicing trying cases in Chicago, okay? And I would make sure that that expert got taken care of and got paid, because at the end of the day, it's the right thing to do. So you as an expert want to have language in the agreement that the retaining entity, the retaining law firm, is responsible for paying you no matter what the local custom may be.
Yeah. And one of the things that our president and CEO, Nabil Zoomout, and I have discussed, and then you and I discussed, and Nabil's here, folks. He is answering some of the questions in the Q&A. He doesn't look as good as I do. That's why, you get the good looks for the webinar. So no, I'm just joking.
Wow. I'm what a compliment.
we had to come, we had to show up, right, Dan, you and I, to sell it. We kid, but he is a practicing attorney, and so if you're getting some questions in the Q&A, that's who is answering those. So thank you, Nabil, for your help there. The one thing that Nabil and I have discussed, and you and I have discussed, Dan, is that there will come that time. However, you've identified the law firm, the retaining law firm, as the responsible party for paying you, but then the check comes from an insurance company, right?
Mm-hmm, mm-hmm.
Well, you're probably going to accept that.
You're going to accept that check. That's just the reality of how things often work. As long as you're getting paid, you're getting paid. And if it's a captive counsel with the carrier, that's the way they issue checks, that's the way they issue checks. If it's a large law firm, or maybe even a small one that is outside counsel handling, let's say, an injury case, and the arrangement they have is the check comes directly from the carrier, it comes directly from the carrier. But you want to make sure the agreement is with the law firm. I have been involved in deals where it was sort of an arrangement, let's just say, that ultimately there were terms where the insurance company was paying, and they were party to the agreement, and for various different reasons. You want to avoid all that if you can. That's the outlier. Sometimes you have to bend the rules a little bit to make things work. As my 10-year-old son likes to tell me, but daddy, rules were made to be broken. And, but in business, it's better not to break the rules, just bend them a little bit if you have to make everyone happy and make sure everyone gets paid and obligations are met.
Yeah, excellent. And so we now turn to the fee schedule, everyone.
Yeah.
And this is just going into the fee schedule. I kind of want to start with, should the fee schedule just be included in the retainer agreement? Should it all be kind of one document?
Something, that is a great question, and I'm going to give you my answer. And my answer is that yes and no. Okay. Yes, I believe that the fees should be reflective within the document. Okay. I also believe, and I'll tell you why in a minute, I also believe that you should have a separate fee schedule. And here's why. Sometimes they just want to look at the numbers. Sometimes they just want to look at the numbers. So someone's going to say, well, if I have a separate fee schedule, then why would I need to have my numbers in the contract? I have seen situations where someone has their terms and conditions of the engagement. Okay. Here's the four corners of the agreement. It's 3 or 4 pages long, 5 pages, whatever. And it says, refer to fee schedule attached, Exhibit A, for the rates. And that fee schedule gets lost, or that lawyer has a fee schedule from 2 years ago that he jumbles up and says, are these the fees, and makes a mistake. I think it's very good practice to have the fees in the actual agreement as well, so there's no confusion. Okay. So if that, as silly as it sounds, if that attachment gets lost, okay, then it is clear within the 4 corners of the agreement what the fees are. Now, that said, a fee schedule is important. It's important for a number of reasons, for sales, for lack of a better term. Because somebody says, oh, I just want to see what they charge. They charge this much per hour, and this much for a half day, and this much for a whole day, and they can see it real quick. But at the end of the day, I think there is good value in having those numbers in the actual retainer agreement as well. Yeah. And I agree. And should you have the retaining party sign both documents? That's a matter of preference. I don't think it's make it or break it if somebody doesn't sign your fee schedule, as long as the fees are reflected within the agreement. I think there's some people who get an extra layer of comfort from having a signature on a fee schedule. There's absolutely nothing wrong with it. There's nothing wrong with it. Yeah. And kind of items, I know we discussed some of the more important terms in the retainer agreement. What kind of items do you think should go into the fee schedule? Generally, the things I see are your record review rates, travel, deposition rates, and testimony rates. But you've certainly looked at far more fee schedules than I have. What do you think goes in there? Well, I think it's important also to put a cancellation term in there if you can. You could line up 10 people, Nick, you and I happen to, agree on most of this stuff, a lot of it. Yeah. I guess part 2 will be the stuff we don't agree on. It can be battle of the wits. So, right. But there's some folks who believe everything should be in the fee schedule, and it should be this grid and like if this, but that, but C square too. And it just gets confusing. I think his fee schedule should be very clean. Review rate, maybe put in retainer amount that's required up front, if it's refundable, non-refundable, testimony rate and how it's billed. travel rate, if there is one, and how it's billed, cancellation terms and how it's billed. And as silly as it sounds, you put in, where to send payment. Don't forget that.
Yeah, don't
And
forget
your
that.
tax ID number at the bottom. So it's really easy for the retaining entity to know exactly how to do that.
Yeah. Yeah, I think that's good. And are there bar rules occasionally that prohibit law firms from paying certain expenses associated with an expert?
That's a really good question. I don't know. I've never been asked that question. Are you aware of any bar rules that, I would
Not in
expect that.
California, but there's,
That's,
so many
I
jurisdictions
love
that,
being stumped. Now I got to go look that up.
yeah, we might have to come back for that one in part two with the marketing stuff. Um, let's see here.
Look,
Oh,
I think as long as you stick to reasonable travel, reasonable reimbursement for meals and things like that, I'm not aware that there would be any problems. Maybe, as you said, in certain jurisdictions that I'm not as familiar with because I haven't practiced there may be very specific rules that apply.
right, right.
So,
Much of this is jurisdictional, folks. So these are kind of some questions that you'll want to discuss with the attorney who is retaining you. Hopefully, they're open. I do want to say one thing that we discussed in preparing for this, Dan, was fee schedules, and here is a slight touch on the marketing stuff. I always recommend to folks not to have a fee schedule on their website, not to have it on their experts.com profile. Keep the fee schedule to yourself. You don't want to have it uh, cached somewhere where some old data and you've updated it and sent it to an attorney and they say, well, this is different than the one I found online. And it is best for your fee schedule to only be shared with that attorney when they're interested in retaining you. I think you and I, again, are in agreement on this. Is that right, Dan?
yeah, I think so. I think that, if there are people who have it out there already and they're like, what do I do now? You can always put, this is my fees effective as of so and so date, and disclaimer. But I think it's better to be discreet. We'll talk more about sort of the advertising and marketing and how to do that. And I think it's really about protecting your business. And I think that's, to your point, is you don't want somebody to have a problem with a credibility issue or a payment issue because someone is, a lawyer or insurance company is saying, well, I found this old fee schedule
This
and
2015 fee
right,
schedule.
exactly. And this is what I'm going to pay you. Right.
Yeah. How about cancellation clauses and fees? Should they be spelled out? And do you have something that is what you consider a reasonable cancellation fee?
Well, look, I think we have experts of many different professions who are joining us today, and what's
Right.
reasonable to someone who is a physician's assistant in terms of a cancellation fee may be very different to someone who's with a large forensic group doing accounting. So I've handled a lot of medical and healthcare experts, but I've worked with a lot of other experts too, up to and including a haunted house amusement expert, which I think was probably my most fun expert find, if
There
that makes
are
my most fun. Isn't that great English? So they're all out there. But I think when it comes to a cancellation fee, and this very often comes into play in testimony, especially with regard to trial, and that may be what you're driving at there. Look, it's a business decision. You want to give the lawyers some room to be able to cancel if their case settles and they don't get hosed with having to pony up a $20,000, $30,000 testimony fee. While at the same time, for example, if you're an orthopedic surgeon and you've made plans to fly from California to Chicago to testify in a case, and you've canceled everything out for 3 days, and then all of a sudden the case settles, what do you do?
Mhm.
So there's a bit of a give and take, okay? So I think it's important that there's enough time where a lawyer can feel that they have a safe harbor to cancel should their case settle, but at the same time, use an expert to protect your bottom line. And if you give them 5 or 10 days and they don't make it, and they cancel 48 hours before, and the testimony fee and everything else was $20,000, $30,000, and you're losing out on that income or portion thereof because you're not going to be able to work those days or
Right.
reschedule patients or what have you. It's the cost of doing business. It's the
And
cost
that
of doing
I
business.
think the main approach there, and why we wanted to talk to everybody today about the business, is you still are operating a business. And as Dan just explained, a day that you're in trial is a day that you're not doing the other thing that makes you money.
Right.
And that, so you do have to be paid for that time.
Absolutely.
That is part of your business. So you want to have eyes on all of these things. You want to chat with Dan or somebody in your local jurisdiction, retain them for your assistance in making these decisions. Dan, we're at 37 minutes in, so we want to get to business entity and E&O insurance
Oh, wow.
before we get to the Q&A. Don't worry, everybody, we're going to put up our contact information and everything while we're doing the Q&A, so you'll know where to get in touch with Dan. But business entities, so there are a couple that I'm used to seeing with my customers at Experts.com. You have two business entities of your own, a law firm and a consulting firm, and in formation of an expert witness or consulting practice. Which entities do you normally recommend for your clients?
The first thing I always recommend, is that a client of mine, whether on the consulting or on the legal side, talk to their accountant. Because 9 times out of 10, I don't have a complete window into their finances. And it's very important that you coordinate this with your accountant or tax attorney who you may be working with. And if you're not, then you want to check in with them. And here's why. I'll just tell you the story of Dan Sandman. And, I shared this a little bit with Nick, and, don't worry, everything's going to be fine. But I started up my business about a year and a half ago, as I said, and I started as a sole proprietorship. And at the end of the day, it caused me some headaches that I think can be avoided, if you start out with an entity rather as a sole proprietorship. And I think that there are tax advantages that you can have, as well as liability advantages that you can have, protections that you can have if you work with an entity. So, for example, in California, when you're an individual practicing law, you can be a professional corporation. So I created a professional corporation. On the consulting side, I was advised by my attorneys who I retained. It's good to take your own advice sometimes, right?
It is very good.
Who I retained, not because anything really bad happened, because I saw what was on the horizon, and I wanted to forestall that going forward as the business grew and risk profile grows and revenue grows, to form an LLC with regard to consulting. And those two are separate entities, and there are tax advantages to each one. And although it works for me, it may not necessarily work for everyone else. And let me sort of lay that out a little bit more, if I could, Nick.
Yeah,
So, for
please.
example,
So you've essentially identified incorporating and an LLC. Those are the
right.
two, right? The
Right.
kind of the main items, and what I often see from my customers as their business entities.
Sure.
But please, go ahead and expand.
So, for example, this is what I get a question about a lot, because so much of what I've done over the years has been identified with healthcare, working with physician experts. They say, well, I've got I'm part of a large practice. What do I do? And I always get the first piece of advice, talk to, your tax people to see what they advise. But if you're coming to me for my legal advice, I would say that the information I would share would be that it's best to have a separate entity. Don't do it as a 1099er. It's best to have a separate entity. That's probably the best way to go, because it also relates to insurance coverage. All right. And you want that entity insured. It'll also probably insure you individually, depending upon how that coverage works. And protects you from a liability and a tax standpoint all the way around.
And I'll do a quick callback for those who were here at the beginning when we were doing an intro here. We talked about the indemnity clause in the retainer agreement. And we're trying to de-risk what you're doing here, lower your risk profile. So something like an LLC or a corporation removes you as the individual, or puts a wrapper around you saying that it's limited liability to some extent. So that's one more level of kind of protection of you as an individual.
Right. And it's just good business. And why the information that I'm sharing is sort of general is because it becomes so specific to what sort of work do you do? Where do you live? What state? What sort of assets do you have? That I hesitate to get really into the weeds on, oh, well, you should do this and you should do that. And, so I think the general advice is that which we have shared. It makes good business sense to talk to the folks that know your profile from an economic and asset standpoint the best, and follow their advice. And then one final piece of information I'd like to share is I did not go to, not that I have anything against them, I did not go to a legal Zoom or anything like that to form my entities.
Mm-hmm.
I work with an attorney and paid a little bit more money, but I had great comfort and peace of mind in knowing that this was specifically addressing the needs that I had for my business to be successful going forward, not just some drop down menu that may work for some people, but just the way I felt about it, I felt more comfortable doing that.
And this is, and I agree with you generally. I come from a family of lawyers, been in the, went to law school, been in the legal technology space now for almost 13 years. And I love the technology aspects,
Sure.
but if I'm, and I think they do a lot of good for a lot of people.
They do.
But I probably am going to go to Nabil or somebody like that, one of my colleagues or family members, and say, I'd like you to review this for me, and I'd like you to put it together. And I know it's going to cost me a little bit more, but I'm going to have more peace of mind.
Yep. There's no doubt about it. And then if you have a problem, there's somebody right there to back you up, and they were there from the beginning.
From the beginning. Again, that same thing we always tell attorneys about hiring experts: get them early.
Right.
The same thing applies to retaining counsel. Get them early.
Or what they say in Chicago: vote early and vote often. So
right.
There you go.
That's right. And this business entity piece really ties in with the insurance aspects of things. And I'll do a little segue or a little transition here. From business entity to E&O insurance is recently, not too long ago, one of my customers, one of the Experts.com customers, had, they were going in to do forensic work. They were an engineer. They were going to offer forensic engineering expert witness services as well. And their company, their malpractice insurer for their engineering firm, the meat and potatoes of their business, they did not want to offer forensic engineering liability insurance.
Mm-hmm.
So that was one of those. So they had to create a separate entity for the forensic operation in order to get malpractice insurance for the forensic operation. And that leads us sort of into E&O insurance and what types of policies are appropriate for an expert witness and consulting practice.
That's a good question. If I may go one before that,
please.
And that is, why should you have it? Because
sure.
I get a lot of pushback. People call me and say, hey, I saw your blog about having E&O insurance. What do I need? What's the likelihood I'm going to get sued? And, oh, my contract has this indemnity provision and limits my liability. Shouldn't that take care of it? Shouldn't I be protected right then and there? And yeah, as you said, Nick, very wisely a few moments ago and a few times, those are pieces of it, the sort of the wrapper, if you will.
Can you repeat that part about wisely? I'd like to get that on the record, Dan.
Yeah, very wisely. You're very wise man.
Thanks.
Very professorial, I must say. So, look, experts get sued. Very often, you're not going to hear about it unless you're at a convention and people start whispering about it. There are very few reported cases involving experts in lawsuits for their alleged malfeasance, if you will, within the confines of an expert witness engagement. There is one that I talk about on my blog. There's one that I posted on LinkedIn. It's called the estate of Grieco. It wound up in the district court, I believe, in New Jersey. And unfortunately, it went on and on and on. And what happened is that the expert who was involved was a physician, and the facts most don't even matter. The point is that physician was sued. Physician is going to incur costs before you even get to settlement of defense. Okay. And it is so important to have this insurance because these policies not only indemnify, but there is a duty to defend. Okay. And so you, at the end of the day, as an expert who, God forbid, you're sued for something that should happen, may end up owing zero. But if you don't have a policy, you're going to end up owing potentially a good deal of money for the defense. And if there's not an attorney's fees provision within your contract and other problems can come up, why would you want to worry about that? So for what ends up being most of, yeah, go ahead.
Allow me to clarify there what you just said, Dan, because I think it's important. What he's saying with the duty to defend is that your insurer is going to hire counsel to defend you.
Correct.
That's not coming out of your pocket. Those are not fees that you have to pay to your attorney. I just wanted to make sure that that was clear for folks.
Now, that relates to another issue in terms of the question you asked, what kind of policies. So when you're looking at policies, errors and omissions policies, and I always suggest working with a broker. I'm not going to endorse any here, but work with a broker you know and trust. You want to make sure you understand how the policy works, because let's say it's $1 million policy. Some of the policies work in such a way that defense costs eat away at the indemnification provision of the policy. So if, let's say you settle a case for $1 million, but the policy is written in such a way that defense costs eat up that million, and it costs $200,000 to defend, well, maybe you only have 800,000, then maybe you could have a little bit of a problem with regard to being on the hook for the remainder. So not that the defense attorney would put you in that position, but I've seen things happen. So the point is to understand what you're getting and working with a great broker can help with that. Okay.
Yeah.
There are terrific online options that people often like to go to find policies that do this. But if you have a broker, they're going to be able to take it to market, get a few different options for you, explain to you the difference between claims made and other sorts of policies that are out there, and what's going to work ultimately best for you.
And I suppose I'll sell your service here for you as well, Dan. I suppose you didn't mention brokers here. Suppose if somebody retains you and you have some ideas of who you would recommend in certain jurisdictions. So
always happy to do that.
Yeah. And we don't want to scare anybody, but you can see this thread that we've now established, this theme we've established through this whole through our whole business of expert witnessing webinar, with indemnification clauses, with limited liability companies or corporations, and now with your E&O insurance. This giving you the most protection personally, removing removing personal liability or de-risking as much as possible, and offering you as much protection as possible is essentially what we've been
talking about. Building
here.
Foundations. We don't want to, it's not, scare, make people nervous. It's about having the best business foundations to be successful.
That's right. That's right. And do you experts get sued, and by whom? This is it's talked about the estate of Grieco, but is it usually the opposing firm, or is it the retaining?
It's usually the retaining firm.
Okay.
Usually the retaining firm. So it's usually the retaining firm, and scenarios that I have seen. Typically I retained expert Jones to testify in my case, and he said the case was meritorious and his opinion was X, Y, and Z. But then when he got on the stand, he completely changed what he was or she was going to say. And things
So,
along that line.
I didn't get what I thought I was getting, kind of thing. And
Things along that line. The expert got what they wanted to get, but the lawyer felt that the expert, did a quick change on them, a turnabout,
Right.
if you will, once they got on the stand. That's a typical scenario that I've seen a number
that
of
you've
times.
seen. Okay. And just for, we've got 270 some odd people here with from all over the US and outside the US. And folks, I promise we're wrapping up here and starting to get into the Q&A. But do you are different types of experts more likely to get sued than others? Is it medical that you see more often than not? Or have you seen it across the board?
I think that the frequency is probably not high.
Mhm.
Okay. It's just the volume of those you do hear about it's pretty loud. And sort of the focus I like to tell people, and thanks so much to everyone who's joined in. And if there's one thing you take away with regard to the E&O insurance, it's this: don't focus so much on what's the likelihood or the frequency that experts get sued, but what you need to do to ensure you're protected if you do.
Yes.
It doesn't matter if an expert gets sued once every 10 experts. If you're that one, that's all that really matters.
That's all that matters. And look, in 13 years of doing this, there's been hundreds or thousands of experts I've known who've never been sued. Which is wonderful, but
Likewise.
you want to protect against it.
Right.
And with that, Dan, I think we've covered kind of the four main items. I think in the Q&A, we'll probably get, I want to leave enough time here. We got about 37 minutes for Q&A. Marketing will be in part 2. You will get emails about when the part 2 portion of the webinar is happening. Dan and I have not yet scheduled, but we're thinking somewhere in the next 30 to 60 days.
Absolutely.
And we will be full on marketing in that one. Now let's get to some Q&A. I'm going to put up our contact information for them while we do this. 1 second, folks. I will and feel free to contact Dan and I if you have any questions that we don't get covered here. And so we've got our first question, and thank you, Nabil. It looks like you answered a bunch of them before we got there, before we got to the Q&A. So keep them coming, folks. We're going to try and answer as many as possible. We're going to answer this one live. Do you believe that an expert witness should have a full-time task? OS, is it better to keep an active practice in one's primary profession? Full-time operating system, is that what you're asking about, Jeffrey? Or keep an active practice in one's practice? I think that what he's saying here is whether or not you're being a full-time expert witness. And my advice generally, and you can expand here, Dan, is that you want your primary practice to continue for doctors who maybe are getting to retirement age and they want to do more expert witnessing than clinical work. I say to them generally, if you could keep a few clinical days a month, a couple, that will make you more desirable by an attorney because you're still keeping current with what's happening. So what are your feelings on the primary practice or the full-time expert practice?
Sure. And again, it comes down to what the discipline is. Are you an accountant? Are you part of a forensic accounting firm that does damages analysis, and that's what you guys are hired to do? Or are you a doctor doing med mal? If you're a doctor doing med mal, you have to be in active practice. You just have to be.
You just have to.
And in my view, and there are some exceptions, which I guess could come up, but I've never, of 5,000, expert witness engagements, I can think of very, very few, other than really, I guess, we're more consulting, or a retired doctor was involved in a case, and it certainly would be a very rare thing if it were a med mal case. And even if it were a PI case, because the questions are going to come up, oh, you haven't practiced for 10 years, and
Right.
that's going to create problems. So,
And so I think for regardless of practice, whether you're an engineer, accident reconstructionist, medical doctor, look, when I first started this 13 years ago, there were still some of those who had left the practice. It was getting much more rare in 2010, but there were still some where they had just left left their clinical practice and were doing expert witnessing, but it was well on its way out of being an acceptable standard.
right.
And so that's why if people are thinking about retiring, but they want to do expert witness work, I say, I get it. You probably don't want it, but you should keep some active clinical practice, whether you're doing 1 day a month in the ER or however, but
Unless they want to do merit screenings of the med mal side. Look,
that's true.
That's still a valid. Remember, there's different ways to slice and dice things with sort of the big universe of experts we have joining us here today. I didn't want to get too specific into one thing or the other, but if you are a doctor and you're thinking of retiring but want to supplement your income or keep active, there's plenty of people who would be interested in having you do merit reviews. Is the case meritorious? Is it not?
Right.
That in sort of screening cases, that's one of the ways that retired docs can get a lot of extra work.
That's true. That's true. Record review stays pretty, can keep you fairly busy as well. And we have members on Experts.com who only do record review.
That's right.
That's what they're interested in. Thomas asks, is it better to have a separate fee for analysis and reports and one for testimony, or the same fee for everything?
That's entirely a business decision. I typically recommend 2 separate fees. That's typically what's done now. For example, $500 an hour for record review, but testimony may be $600-700 an hour. I'm just throwing this out as an example. That's typically what we've seen and what I recommend. There are a good number of experts out there who say, you know what, that's just too complicated. I've got to track all this. It leads to too many questions. I'm just going to charge X for whatever work I do. And if that's what you're comfortable with, if that's where your comfort zone is and you feel that works for you, there's nothing wrong with it.
Forgive me for, I think I just messed up our.
Well, we see your whole.
You're seeing everything now. One second. There you go.
There we go.
There you go. Yeah, I appreciate that. And I think that answers Larry's question about, do you recommend a blended rate and travel is 50% or something to that? I think this is all sort of a business decision for you.
Sure. And the travel thing, again, that it can be very discipline specific. Comes up if you're going to the depot, or you're going to do block billing, hourly billing for travel, or you're going to include travel in half day or full day rates. There's a number of different ways to handle it. Some people say, look, I'm going to charge $10,000 a day for testimony, and that's portal to portal. If they have to go from their office in Beverly Hills to downtown Los Angeles and whatever. But there's a number of different ways to handle billing, blended rates, block billing, hourly. It comes down to what you're most comfortable with. One of the things I do are just fee schedule and billing consults to help people through those questions. And it's very specific. It's your business. Your business doesn't, Nick, your business doesn't have to be like my business, and my business doesn't have to be like your business. And we can both be successful.
That's right.
And that's why having a counselor, someone who really understands expert witnessing, whether you talk with Nick, whether you talk with me, whether you talk with Nabil or other people about what our best practices and how you can integrate them into the work that you do.
That's right. That's right. And this is a good one from Steve. I see a couple. I do want to remind folks that please go through. We've got tons of open questions. Please go through and give a thumbs up to upvote questions that you might also want answered. That'll help us to identify those that are of greatest interest to the most people, because I know that we have a significant number of different backgrounds with us here today. In retainer agreements, can we spell out Zoom only depots and Zoom only trials? My answer to this is Yes, you can, but it may impact work. It may impact your business.
Hey, you could spell out anything that you want in your agreement, but ultimately that's up to the judge as to whether you need to be there in person. And I think what I have seen is people putting on fee schedules sort of a Zoom rate if they want to have something different than an actual live in-person rate. But your question, or the question that's being asked, is really, it seems to me to be about, can I sort of get out of having to travel across country to testify and just do it by Zoom based upon what the terms of my contract are? I think Nick kind of answered that question. Maybe I'll let you elaborate a little bit on what you meant there, Nick.
Yeah, I don't
But,
want you to
yeah.
be, I'm not going to get in trouble for any legal advice, but it's going to look bad to your retaining, to the retaining firm if you're putting those kinds of, it'll be bad for business is my feeling. Now, most people these days, most firms these days are interested in having you do Zoom deposition.
Yeah.
Because that is generally a lower cost, but you have to be available for trial,
Mhm.
which in the very unlikely case that it goes to trial, they're gonna want somebody who is who's on the stand in person. And so if you're saying up front, I only do Zoom trials, probably you're not going to get retained by those who are interested.
I'd agree.
Yeah. Can your retainer size deter a client from hiring you?
Yes. Next question.
It's true. It's very true.
No, we don't mean to make light of the questions. I'm sorry, I should have done that, but it's true, and it can. If you're charging a $10,000 non-refundable under any circumstances retainer, and someone sends you 500 pages of material to review, and that's all they have, that's really not going to work. And you need to be reasonable, need to understand what the engagement is, need to have a sense of what the market is, if you will. There are a lot of people entering the expert witness space right now, others who have been dormant in it and becoming much, much more active. It is extremely, extremely competitive. I'm not talking about dropping rates or anything like that. I'm talking about smart business. At the end of the day, if you need a $10,000 retainer because that's kind of what the case warrants and that's what you need, then that's what you charge.
Yeah.
They're ultimately going to know what is going to work based upon your interaction with clients. But again, if it's your basic medical malpractice case, and if we can use this type of example in medicine, and you're going to charge 10 to 15 to $20,000 retainer, and it's non-refundable, and the lawyer just has 300 or 400 pages, you're not going to get retained. And then other lawyers are going to talk in the chat rooms about how Dr. Smith, he only charges a $15,000 non-refundable retainer, and even though he's the best, my case doesn't warrant that, and maybe I can go to this guy over here who can get me what I need. So in all sincerity, I think that, yeah, I think you probably agree with that, Nick, that
Yeah.
You charge too much and it can leave sort of a bad taste.
It can, if you're thinking about, and we'll talk about, I think next webinar, part 2 of this, in the marketing and really that's the marketing is also the sales side, Dan, that we need to talk about for folks.
We do,
because this is part of your presentation to attorneys, and repeat business should be on your mind from the beginning, and then staying in touch with that repeat business or potential repeat business is important.
mm-hmm.
This question is, do you have any suggestions for what to do after the original retainer is paid, the final invoice is not paid by retaining counsel? So Joe, if I'm understanding this correctly, they paid the retainer, but they're not paying the whatever is outstanding. This is a collections issue, I believe, Dan.
Yeah, it's so upsetting when it happens.
Mm-hmm.
It's so upsetting, and I've spoken to experts over the last years who are faced with that situation. I think the most important thing in any expert witness engagement is to remember that communication is extremely key. It's more than just about having a retainer agreement and getting the money and billing and doing the work. Communication and the relationship are so important. I know we're kind of going to get into this more, Nick, on the next one, but it's so
Yeah.
important. And the reason I say this is that some experts sort of forget about that. And I'm not talking about being wined and dined or whining and dining the lawyer, but it's sort of how you handle yourself. And that can go a long way to ensuring these things don't happen. That said, you can do all the right things in terms of building a relationship, and it happens anyway. Persistence pays off. You've got to be persistent. You want to have terms in your agreement that if they don't pay you at a particular point in time, that you're not going to do additional work and that you can terminate that agreement. You want to have terms within your agreement that talk about interest, perhaps on late payments, things of that nature. There's some people who suggest that if things get really bad, that you take things to the state bar and complain, beef a lawyer to the bar. That's what we used to call in Chicago. He got beefed,
Right.
to the state bar. You know, my understanding of these issues is that typically the state bar doesn't want to get involved in a business dispute unless there's some sort of potential fraud or crime that was committed. And ultimately, these things are business disputes. This is why it's so important to have a contract, because if somebody said they were going to pay you or were supposed to pay you because you did the work and they don't, you have that contract in addition to the invoice to fall back on. You need to ultimately hire a lawyer and get them involved to work things out. That's something that I do. I'm also trained as a mediator, and I like to get involved when needed in these sort of situations and work them out. And a lot of the time, it's about a miscommunication that got blown out of proportion, and someone's angry and doesn't want to pay, and the other side is angry and doesn't want to come down on what they believe that they're fairly entitled to.
There's an issue. There's a issue in between these two items, if I understood that question correctly. Or I want it's of concern to me, so I want to make this clear. This particular question said you had the retainer agreement and then they didn't pay when it was all done. There should be billing taking place between those two times.
Oh, absolutely. Oh, don't wait to the end. Yeah.
Don't wait till the end. You know, whether you do it monthly, and this should be in your retainer agreement. If you go to Dan or your local attorney, you know, check with Dan, contact Dan, retain Dan so that he can guide you through this. Otherwise, you really have to have a billing practice that, you know, on the first of each month, you know, statements are going out, and this is what's been accrued and what is owed this month. I think that is an important way to establish a business arrangement that says, this is how I get paid.
Stay on top of the billing. You got to stay on top of the billing. Don't wait to the end. Don't wait 3-4 months to submit a bill, because I guarantee you the lawyer will not like that.
Yeah. And then they're getting sticker shock.
Sticker shock.
Time. Yeah,
that's right. That's the best. That's the best way to say it.
I think this next one was it related to when we were discussing termination of the agreement in regards to dauber challenges. This expert says he'd want to be notified of a dauber challenge and be able to collaborate on the response. Are you suggesting? And it would only be a suggestion here. Again, no legal advice. Are you suggesting potentially terminate the agreement if you are not notified of a dauber challenge?
Those are terms that I have seen in expert witness agreements. Yes, you need to be notified. That's a major issue. You need to be notified. You need to be able to participate in making sure that goes well. There are some lawyers out there who drop the ball or don't want to touch the ball or swing and miss, and they kind of want to hide what happened. That's not a good situation.
But this could result in you having a dauber. You know, if they find that you're not qualified for this, that's something you need to know, and the attorney should have told you about that.
Absolutely.
And let's see, our next one down.
We only have 41 more questions to go.
Yeah, I'm trying to, that's why, please, everybody, there's hundreds of you in here. Please read the Q&A and vote them up. So
I'm
we
happy
get,
to answer them all. And if we run out of time, just shoot me an email and I'll
yeah, that's true.
the best that I can do.
Best we can do here. How do you feel about the concept that for an initial review of records, the expert will charge a fee per page? Then after that, everything is billed hourly. I've never seen this. I'll tell you that much, Dan.
Yeah, I've seen stuff kind of like that. The question is, well, how many pages are there and what are you going to charge, right?
Yeah.
I mean, what I've seen more frequently is that regardless of how many pages there are, or let me rephrase that, I charge a flat fee of $3,500 to do an initial review of up to 1,000 pages. And then if there's merit, then I charge hourly for all my work after that. Or then if I can help with the case, things of that nature. I've not really seen a lot of the per page review. I think that probably would only work if there were a decent volume of pages, because, I guess if I were the lawyer, I might like that, and charging $1 a page and he has 10 pages, you just got a great deal, right? But it's not such a good deal for the experts. I apologize, because I think there's a contextual, I don't know if we can know the specialty of this expert. I think there's a contextual piece missing here where I'm not
true.
really sure what they're asking, or in what context.
Yeah, I've never seen this. I guess in it could be in medical record review. I have a feeling if you were in digital forensics and you were getting 1 terabyte of data, that they are not going to be happy that you're charging $10 per page. Right. And what constitutes a page. So,
right.
So I think in those situations it'd be very different. But again, in my 13 years, I've not heard anybody say I do a per page charge. I've seen attorneys do it on copies made in a law firm.
Yeah, we've all seen that, right?
We've all seen that.
All right.
But I haven't seen it here. Isn't an attorney an agent of the client? If so, isn't the client legally responsible for the expert fees? I.e., the attorney is an agent of a disclosed principal, and this goes to who we're having sign a contract, I believe. The attorney is an agent of the client. The client may be legally responsible for paying the fees. You, as an expert, want the attorney on the hook. Let them go after their client for fees. You want to know exactly who who's retained you, and as an expert, the attorney is the one who retained you.
I think that's a good answer. I think it's a very good answer.
Yeah, I appreciate that. Okay. This is interesting. Can you use a Microsoft clause in lieu of a signature to activate an agreement, such as you break the seal on the software to agree to the terms, or if they send you materials to review, they agree to the terms of the contract?
Well, that is a very, very interesting question. And I think the easiest solution to something like that is to not do that. And in my opinion, is to have somebody sign the contract, whether it's a wet copy that they fax over to you, or fax, I can't believe I said that, scan over to you, or whether it's one of the technology solutions for signing agreements, such as, dare I say, DocuSign, or others like it, that can make it very, very simple to sign an agreement. And I believe some of these programs, and I'm sort of invading your space here, Nick, so I apologize.
That's all right.
Some of the programs will even store your signature if you want to allow them, so that you can sign automatically as the expert, not have to, it can be automated, I guess is what I'm trying to say. It can be automated. Once your client signs it, then you can then sign it afterwards.
Right. This one is interesting. So say your client calls and says the insurance company will settle, but
Mhm.
you would have to take 50 cents on the dollar, for example. What can you put in the engagement contract to prevent this? My answer here, and Dan will elaborate, I suppose, is your rates are non-negotiable. Whatever the attorney and the insurance company agree to, that is separate. But Dan, maybe you have something else to say here.
So if I understand the question correctly, it's you get a call from the lawyer saying the insurance company will settle, but they're going to settle for, let's say, $50,000, but the expert fees are 10,000, and the lawyer only wants to pay you 5. Is that kind of what we're
I
understanding?
think that's what
I
I'm
think.
getting. Yeah, the kind of the negotiating down the expert fees because
Yeah, right. Yeah, sorry, you dropped there for a minute. I'm sorry. Can you hear me?
no. Yep, I got you.
Look, that's a business decision, and that happens. Okay. I'm not saying that somebody should agree to do that. However, it depends how you have set up the billing for that case. All right. If you're a physician, especially, and really for much of this work, it's best to do it on a retainer basis. Best to do it on a retainer basis. And what that means is that you have your contract scheduled in such a way that when the retainer starts to be depleted, you go to your client and say, hey, I'm down to the last XYZ, last hour, 2 hours, 3 hours, whatever.
Mhm.
If you want me to do more work, and I believe you do, then I'm going to need the retainer replenished within this period of time for me to continue. That sort of alleviates that problem. Now, it doesn't alleviate the problem if you haven't been doing that, and then there's sort of an AR billing that you're trying to collect. On the flip side, this may be a question that is specific more to personal injury. Maybe the person can give a thumbs up if that's the case, where someone has a lean in on expert work, because that kind of sometimes happens in the personal injury realm, and they're trying to negotiate down your fees in that regard to try and get a case resolved. Again, I'm not 100% sure the context, but my advice and the information that I would share with people, advice from a business sense, not a legal sense necessarily, is that work on a retainer basis and try and avoid those situations if you can.
Yeah, I think that's good. Good suggestion, and reach out to Dan again. You'll hopefully you guys all see our contact information here, both emails and websites available. Do you see a problem with law firm retaining an expert, but end client agreeing to indemnify and hold harmless the expert?
I didn't hear the whole question. Something
Sorry.
about.
So the law firm does the retaining, but the end client or the client of the law firm is the one who is agreeing to indemnify and hold harmless the expert.
Well, that would be, they'd have to sign that agreement. And typically I would not advise that an expert do an agreement with the actual litigant. And that's what would be required there from what I
Reading.
understand. So if there's no privity of contract, then it wouldn't matter. So you'd have to have them involved in the contract, if I'm understanding the question. And that's not something that I would advise.
Right. This question is, we got to one of the E&O ones here.
Mm-hmm.
And please, folks, we got about 10 minutes left, so we're not going to be able to get to all the questions. If you can upvote those that may answer your question, please go ahead and do it. It's great. We've got a huge showing here, but I have E&O insurance, but what addition should there be for any forensic work? This is kind of that example I had recently with my engineer who had to create a new entity in order to get new E&O insurance for forensic work.
Do I'm sorry to interrupt. Do we know what kind of specialty this expert is?
We
No?
don't,
Okay.
but she does indicate DNA, et cetera. So maybe some sort of a forensics or medical forensic uh,
That,
aspect here.
yeah, I think the best answer to that question is it comes down to what's in your policy. If the policy doesn't cover forensic work and doesn't cover your work as an expert witness, as you will, you need to call your broker or the company and say, hey, I'm doing this sort of work. I want to be a testifying expert in court. Does the policy cover that? Can you please write back to me and explain whether this scenario would be covered? The insurance company 9 times or 9.8 times out of 10 is going to write back and say, hey, based upon you tell us this is not covered. Then you know that you need to go out and get a specific policy to cover your expert witness / forensic work.
Excellent.
Don't be afraid to ask the insurance company or broker, if you already have some sort of coverage in place, what there is for forensic work. I mean, they're there not only in times of need, if you get sued and that sort of thing or claimed against, but also they'll answer questions and assist you with letting you know what is in the policy and not. And these policies typically aren't very long. Take the time to read them, because you may be able to find the answer yourself and save yourself some time.
Great. Why do some lawyers, this is a fun one, why do some lawyers only want only one expert versus 2 or more?
I think that if I'm reading the question right, and I think, Nick, you're just smiling, you're loving this, really to save money.
Yep.
I think is the main, having sort of been there before.
That's my answer.
Really to look, it's expensive to litigate cases. It's expensive. And if it's on the plaintiff side, then in most cases, if it's a contingency arrangement, then the law firm is fronting those costs and whatnot. And if it's a private client, even if it's a plaintiff, maybe that client is price sensitive. So it's usually a dollars and cents issue.
Yeah, it seems to be.
Yeah.
There are occasions as well that it is an efficiency thing, not just cost effective, but if they can find somebody who is capable of answering both the mechanical and the electrical aspects of it,
Sure,
it may just be easier for them.
Fair enough.
But generally, it's a cost thing.
I think we're in agreement on that.
Yeah. Let's see. Oh, this, we were going to try and touch on this. This is a good one here. We were going to try and touch on the state of the industry stuff, which I think will probably will give a little bit of coverage here, but probably more in part 2 or maybe part 3. But some of us are super seniors. Our future is now. Anything special we should worry about or do? Boy,
what do they mean by super senior? Like they've been doing it a long time.
Been doing it a long time is how I'm taking that.
I don't, again, it comes down to practice specific, what their specialty is, but I don't know that there's been a better time in recent memory to be an expert witness. I think we're seeing likelihood of greater litigation to occur based upon my read over the next several years. If you look up Entrepreneur Magazine, there was an article written some months ago, and I meant to bring it with me. I'm sorry I didn't, but I can share it with those who email me, about the expert witness industry as a whole, not just entities, but individuals sort of flying under the radar and just really exploding right now. So I guess if you've been doing it a long time, maybe the increase in competition could be something to think about, but there's also going to be so many opportunities, and lawyers really like accomplished experts who they can rely on, who haven't who have good track records. So, I think it's a good time to be an expert witness. There's always threats, strengths, weaknesses, opportunities, threats, if you will, to an individual expert's practice and also an organization of expert witnesses practice. But I think now is a good time to be an expert for those who are in it and those who are entering the space.
Yeah, I think one of the things there that I think is worth stating, it is a good time to be an expert witness. What I've seen continuously in 13 years is the more specificity in niching down expert work. What may have one day required a psychiatrist now requires a forensic psychiatrist and a forensic psychiatrist in PTSD. The same goes for many of the technical specialties. What was source code review may have applied broadly. Now it's very specific, different types of source code. Mason's here. I know he's in the blockchain space. So I think we're getting far more specific and far more niche down in the area that somebody is practicing as an expert. Have you noticed the same, Dan?
There's no question about it that the expert needs to be an expert, needs to be an expert, needs to be an expert, right? Niche, 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 niche. Things are really going into very niche directions as lawyers become more sophisticated in looking at their cases and utilizing consulting experts who then pick out the real tiny little issue that turns out to be the key to the case. And then those testifying experts are going to be so needed within the niche areas. So yeah, I'd agree with you.
It looks like this one, we thank you, Stephen. He liked the webinar.
Well, great. Thank you.
What is the best way? What is the best way to be sure none of your partners is involved in a case you are asked to review by an attorney? So this is a conflicts check, I believe.
Yeah, I'm guessing this is someone part of a forensic firm, perhaps, and you got to have systems in place to check conflicts and conflicts, and maybe it's a doctor, actually who's in a large medical practice who finds out later down the road that there's a conflict. So there's systems in place. The systems need to be in place where you're checking for conflicts. You also need to have information in your retainer agreement that if a conflict is discovered, further down the line, then you would have to be able to bow out.
Yeah, I think that is important, and hopefully you will be able to do this conflict check up front. I recently, let's take one more. We got a minute here.
One more.
Let's do. I recently had a client attorney refuse to sign a retainer agreement and wanted us instead to sign his COVL agreement. I don't know what that is. Maybe it's their agreement. Any advice on this situation?
Again, I don't know what that term means, that type of agreement, but what I would recommend is that if they refuse to sign your retainer agreement and you want the engagement and you need to sign the law firm's agreement, better get a lawyer to look at it first so you know what you're signing.
Yep. So reach out to Dan at sandmanlegal.com is his email, and you can visit his website at sandmanlegal.com. I think we're at time, folks. I want to thank everybody who was here and stayed through the whole thing. I'm sorry we didn't get all your questions answered, but we will stay tuned. We'll send you a recording. A lot of people are asking about the recording. Yes, it'll be emailed to you next week. And stay tuned for more emails from us about part 2, where we're going to focus on the sales and the marketing aspect of the expert practice.
Can I give them a little taste? Can I get a little
Please
taste?
give us a little taste.
Remember,
Dan.
I like to talk about the more concept when it comes to marketing, right? When it comes to developing a practice, media, you got to be present in at least one channel and try to own it. You got to outreach, laser focus on the target business, and don't be afraid to ask for business. I know Nick's a good one at that. Relationships, he's great at that too. They equal revenue. I'm going to develop those relationships, and content is king. And those are just a few things I know we're going to talk about next time.
Yep. Yeah, it should be a good one. We've both been at this from two different perspectives. So we've got and perspectives that we think are complementary.
Absolutely.
So we hope to see you then. Thank you, everybody, and we will talk to you. Dan, thanks so much for doing this. I'm looking forward
Thank
to
you,
the
Nick.
next time.
I appreciate it. Great job.
And you as well, sir. Have a good one.
All right. Talk to you soon. Thanks, everyone.
Bye-bye.